Court's going to call 23 TRD 3200 State versus Chris Yoder. Mr. Yoder, you want to come on up, sir? You just have a seat over here, Mr. Yoder.
Your Honor, if I may, at the end of last week, we received some letters from Mr. Yoder in the file that it appears that the court has treated previously as motions to dismiss.
You may have something I don't, Mr. Lefty. I have a letter, and then I have a separate photocopy of an article from a newspaper or publication that Mr. Yoder sent. But when I read his letter, the only letter I have was just dated, looks like it was postmarked May 3rd. I didn't see any request to dismiss in the letter.
I don't believe there is a direct request to do that, Your Honor.
I didn't see it as a motion because it wasn't requesting any relief. It just seemed to be explaining why Mr. Yoder was arguably not complying with the statute, but I didn't see it as a motion to dismiss, which is why I didn't set it for hearing. State disagree?
I'm not certain, Your Honor. The State's prepared to go forward on the facts of the case. The State's not prepared to go forward on a motion to dismiss. I have an additional handwritten 2-page letter that's in my file.
May I see it?
This is your, from you.
Yeah, that's mine. I think that's the letter I have.
Oh, yeah.
Well, let me see. I'm not sure. Yeah. Yes, yes, okay. Yep. Those are the two I have, but I didn't see a request for relief from either one of them. Now, State's prepared to proceed?
Yes, sir.
Are you prepared to proceed, Mr. Yoder? Are you prepared to proceed with the trial? What does that mean? Well, you were here back on April 25th, and you were charged with operating a buggy on a public road, a horse-drawn vehicle, without a flashing yellow light. You pled not guilty, and I set it for trial today. Are you prepared to proceed with that trial? Yes. All right.
Sir, you're going to need to speak up, please, so I can get you on recording.
Have you ever been in a trial before?
No.
Okay. Well, then I want to have a little conversation with you before we start. And I'm sure we probably gave you a little blue pamphlet to look over before you came back today.
Cardinals?
Yes. Did you look that over? Okay. Now, the first thing I want you to understand about the trial is that you are presumed innocent. And what that means is that you don't have to prove anything. Okay? You pled not guilty, so all that the law really requires of you is that you show up today, and you've done that. You don't have to come in here and prove that you're innocent. The state has the burden of proof. They brought the charge, so they have to prove the charge. They have to prove by evidence beyond a reasonable doubt that on or about April 17th, 2023, in Ashland County, Ohio, you were operating a horse-drawn vehicle and that it did not have the required flashing yellow light. If they fail to prove any of that, even one part of it, I will be finding you not guilty, because the state has to prove every element of the charge by evidence beyond a reasonable doubt. Now, because the state has the burden of proof, they get to go first. So the way the trial will work is we will start with what we call opening statements. That is an opportunity for each side to tell me what they think the evidence in the trial will be. Opening statements are not evidence. It's just a chance for each side to tell me what their side of it is. They're going to tell me why they think that you're guilty, and you can tell me why you think you're not. You do not have to make an opening statement if you don't want to. Once opening statements are over, Mr. Alecki, on behalf of the state, is going to call his first witness. That witness will come up here to this chair, and the bailiff is going to swear them in. They're going to take an oath that they will tell the truth. And then Mr. Alecki is going to question that witness. Now, when he finishes questioning that witness, I'm going to ask you if you'd like to ask the witness any questions. Now, you don't have to do that, because, again, you don't have to prove anything. But if you would like to question the witness, you have that right. If you ask questions, Mr. Alecki will have the chance to ask more questions, but he will be limited to what you asked about. He can't go off and ask about new things. And once that process is completed, that witness will stand down. He will call his next witness if he has any. And that process will repeat with every witness the state has. Once the state is finished, I will ask you if you want to present evidence. Now, you are not required to do that, but you have the right to do so. So if you have a witness you want to call about these events, you call the witness, they'll come in just like the state. If they're uncomfortable taking oaths, I'll let them affirm that they're going to tell the truth. But the witness will be sworn. You question the witness, prosecutor questions the witness, back to you, witness stands down. Process repeats with every witness that you call, if you call in. You can testify if you want to, but you don't have to. And you cannot be called as a witness against yourself by the prosecutor. If you choose not to testify, that fact is not going to be held against you in any way. I'm not going to assume that you must be guilty because you didn't testify. It doesn't work like that. You don't have to testify if you don't want. If you do decide to testify, you have to do it from the witness stand. You have to do it under oath, which again, it's fine with the court if you just affirm to tell the truth. You don't have to swear if you're uncomfortable swearing. Then you can just tell me whatever you want me to know about the case, but you will be subject to being questioned by the prosecutor if you decide to testify. If you present any evidence at all, the state has the chance to present rebuttal evidence in response. If you don't present evidence, they don't get another chance. Then that will conclude the presentation of evidence after both sides have had a chance to call witnesses. The court would normally listen to some closing argument from each side as to why they think that they were successful, and then I'll rule on this. I will rule on this case. Probably, and it's a minor misdemeanor equipment violation. So I will rule on it today if I can, so you don't have to come back. But if I can't do that, if there's something I want to think about or I want to take a look at the law, I could take it under advisement, issue a written decision later, but I would try not to do that since it's such a minor level offense. Any questions about any of that?
I do have two witnesses, so whenever you need them, you can.
Well, when it's your turn to call them, you just tell me their names and we'll bring them up.
Okay.
Are they in the courtroom right now?
I think they are.
Okay.
Yeah.
Well, anyone that's going to be testifying as a witness, except Sergeant Saylor and you, have to wait outside. They can't listen to other witnesses testify.
Okay.
So I'm going to ask that Mr. Yoder's witnesses wait in the lobby, and then we'll call you when he's ready for you. There's one. There's two. Thank you, gentlemen. Any other questions, Mr. Yoder? Now, I can't give you legal advice. I'm not your lawyer. But if you have a question about how to do something, I can probably help you with that if you want to ask me. If you want to do something and you don't know how to do it, I would much rather have you ask me than just not try, okay? Because I do want to hear your side of it.
I was never in there, so
It's okay. I understand you're not a lawyer, but don't expect me to help you without being asked.
Yeah, no.
If you have a question, you have to ask. Mr. Olecki, any opening statement?
Your Honor, the state would waive opening statement.
Mr. Yoder, do you want to make an opening statement?
What's that?
Well, that's what I just explained to you. Your chance to tell the court what your side of this is. Do you want to do that? Go right ahead.
You mean for,
If you want to make an opening statement, this is your chance.
oh, okay. You mean about why I don't want the lender or?
Whatever you want me to know about this case.
Yes, my reason for pleading not guilty, I'm not allowed to have lender. It's against our rules in the church. And so what can I do? If it's against my religion, what should I do? It's not going to work in the church, but it's not going to work for you guys.
Okay. Is there anything else you want to say?
What's that?
Anything else you want to say?
And I think our bookies are visible. I mean, we got reflective tape on the back and also some on the front. We got 2 landers on each side. And we also have the pipes on the side of the wheel. And we got that white block on the back with reflective tape. And I can't see why our bookies are not visible the way they are.
Okay, Mr. Yoder. First witness.
Your Honor, the state would call Sergeant Daniel Saylor.
Sergeant?
You swear affirm testimony you're about to give in this case be the truth, whole truth, nothing but the truth. If so, say I do.
I do.
Have a seat, please.
May I inquire, Mr. Olecki?
Thank you, Your Honor. Sergeant Saylor, can you state your full name and spell your last name for the record?
Sergeant Daniel Saylor, S-A-Y-L-O-R,
And Sergeant Saylor, by whom are you employed?
Ashland County Sheriff's Office.
And how long have you been employed by the Ashland County Sheriff's Office?
Approximately 7.5 years.
And how long have you been a sergeant?
Recent, couple months.
Congratulations.
Thank you.
Can you briefly describe the training that you had to go through to become a sheriff's deputy in the state of Ohio?
Sure. Anybody that wants to become a police officer in the state of Ohio has to go through the police academy. The time I went through, about 9 years ago, it was 650 hours required. It's gone up since then. Every year, every officer, every peace officer in the state has to go through continued training throughout the year for a certain required number of hours. Then we have additional classes that our sheriff's office may host, and our bosses may say, hey, you are going to go to this, or you may request extra classes and go to those classes. So there is always continuous training.
And did you successfully complete your training at the that you described at the police academy?
Yes.
And as of April 17th of this year, were you current and up to date in all your required training?
Yes.
And as a sergeant, what a brief description of your duties with the sheriff's department?
So I'm the shift supervisor for second shift on the enforcement division. So we are the individuals that are patrolling on the roads and making traffic stops, responding to calls, anything from, lost cat to, to, a house fire or something. We could do it all, and we're the guys driving around out in the county.
And were you working this year, Monday, April 17th, approximately 6:30 p.m.?
Yes, I was.
And what were you doing that day at work?
I was assigned to the north zone, so if we have 3 people working, one of them will cover the north end of the county, one will cover the middle, and one will cover the south. So I was working the northern end, patrolling. I went up 42, 89. I was patrolling in the Polk area at around that time.
Were you in a marked patrol vehicle?
Yes, I was.
Were you dressed in your sheriff's uniform that day?
The uniform of the day, so it still had identifying patches on it, but we have an outer vest that we wear when we patrol.
And On that day, Monday, April 17th, approximately 6:30, did you happen to come into contact with the defendant, Chris Yoder?
Yes, sir, I did.
And is the defendant seated here in the courtroom today?
Yes, sir.
Can you point him out for the court?
He's sitting over here at the defendant's table.
Where were you when you first encountered the defendant?
We were both traveling on County Road 800. He was going westbound. When I came up behind the buggy is when I realized that there was no yellow flashing light on there and tried to initiate the stop. We were in about 300 block.
And that location in on County Road 800, is that in Ashland County?
Yes.
And, I'm sorry, were you traveling the same direction?
Westbound, correct.
Westbound,
Came up behind the buggy.
And so when you encountered the defendant, was he operating a buggy?
Yes.
Was it animal drawn?
Yes, sir.
Horses?
Yes.
Was the defendant the individual operating the buggy when you encountered them?
Yes.
He would have had, did he have the reins?
Yes.
Was there anyone else in the buggy with the defendant?
Your wife and child was with you. Young child.
When you encountered the defendant operating the buggy on County Road 800, was there a yellow flashing light visible on the buggy when you encountered them?
No, there was not.
There was no light on top of the buggy, yellow
No.
light flashing? In the back of the buggy?
No.
Did you initiate a traffic stop of the defendant?
Yes, sir.
And why was that?
Because it did not have the yellow required light on the back top of the buggy.
Did you issue the defendant a citation?
I did.
And what was the citation?
It was for not having a yellow flashing light on the buggy. It was his first offense that he'd been stopped for.
And in issuing the citation to the defendant, did you follow all of your training and regulations?
Yes.
Did the defendant say anything to you when you encountered him?
Typically when I run into these situations, I'll ask, just try to be friendly and try to find out what's going on, why he doesn't want to have the light on there, if it's his own personal choice or what's required. So a lot of times it's the bishop that will not allow them to put that light on there, and he explained that to me, and he said it was against their beliefs, and that was the reason he did not have the light on the buggy.
Thank you. I don't have any further questions, Your Honor.
Mr. Yoder, do you have any questions you'd like to ask Sergeant Saylor? Sergeant, you can stand down, thank you.
Thank you, Your Honor.
Any further witnesses?
No further witnesses, Your
Any
Honor.
exhibits, Mr. Lance?
No exhibits, Your Honor.
So all the state's going to present, Mr. Yoder. Do you have a witness that you wanted to call? Who would you like to call first?
Just one at a time.
Yes, one at a time.
Okay, William Zook.
William what?
William Zook.
Zook. William Zook, Mr. President.
William Zook. fine right there, sir. Turn and face me and raise your right hand. Raise your right hand.
What's the issue, Mr. Zook?
Not an oath?
You don't have to take an oath. You're welcome to affirm that you're going to tell the truth if you'd like, but you'll still need to raise your right hand.
Do you swear or affirm testimony you're about to give in this case be the truth, whole truth, nothing but the truth? If so, say I do.
And you're welcome to say I affirm if you prefer.
I affirm to tell the truth.
That's fine, Mr. Zook. Thank you.
Come through the gate here. Watch your step. This is your microphone. You'll need to speak up, please.
All right, Mr. Yoder, you're a witness. You're welcome to ask Mr. Zook any relevant question.
You think our bodies are visible the way they are?
I think so.
Also do I.
I have observed buggies in the daytime. I could see a buggy from a half mile away.
Objection. We're not here today on the reasonableness of the statute. I believe we're here because we have a statute in place, and the question for the trial is whether the defendant violated the terms of the statute.
Mr. Alecki is objecting to that line of questioning because it's not, his assertion is it's not relevant, okay? That this is a trial and whether or not on April 17th you had a light on your buggy. That this is not a hearing about whether or not it's good law or whether it's necessary law or whether you can see the buggies. This is a trial about whether or not you had a buggy light.
So you're asking why I didn't put it on?
No, why you didn't put it on isn't particularly relevant to this hearing. This is a trial about whether or not you had it on. That's what this is about.
I know I didn't have it on. I did not have one on, but it was because my relationship wasn't letting me.
Okay, I don't have a moment's doubt of that, Mr. Yoder. I'm going to sustain the objection that the testimony elicited is, for this hearing, irrelevant. Other questions?
No.
Did he cross?
No crossing.
Mr. So you went in the buggy on April 17th.
I was not.
Sir, you can stand down. And at this point, you're welcome to stay in the courtroom if you want to. You have other witnesses, Mr. Yoder?
Peter Miller.
Peter Miller, Mr. Councilman?
I'm sorry I didn't catch it. First name
Miller,
please.
Peter Miller?
Peter Miller.
Miller. Okay, thank you. Peter Miller, please. Please, sir. This way. No, this way. Up towards the judge. Turn and face me, please, sir. And you may affirm, raise your right hand. Your other hand. You swear affirm testimony.
You need to raise your right hand, Mr. Miller. There you go.
Do you swear affirm testimony you're about to give in this case be the truth, whole truth, nothing but the truth? If so, say I do, or I affirm. I affirm. Have a seat, please, sir. Go up here through the gate. Watch your step. You will need to speak up for me, please. Your microphone is right here.
Okay, Mr. Yoder, you can ask Mr. Miller any relevant question about the events of April 17.
Do you think I should put a blinker on or not?
Objection, Your Honor.
Just a second, Mr. Miller.
Relevance, I'm not sure who Mr. Miller is, but his opinion as to whether the defendant should put a blinker on or not is not relevant.
What is the relevance of that? Why do you think that the court needs to hear that, Mr. Yoder?
Well, I'm just trying, I didn't know why you want me to ask.
Oh, it's not about what I want you to ask, okay? It's about what they have to prove. This is a trial about whether or not you had a light on your buggy on April 17th. That's what it's about. Now, if this witness has something to say about that that's relevant, then I want to hear it. I don't know what he knows about this. I don't.
But you mean if he has something to say about it, it's what you're asking?
Yeah, Mr. Olecki is objecting to the question because he doesn't believe it's relevant. So I'm asking you, why? This is what I'm trying to explain to you, and it's not easy to explain. It's something I deal with every day. So, but when I have to stop and explain it to somebody, it's hard. The only evidence or testimony that can come into a trial is evidence that's relevant. Okay, and relevant evidence is evidence that makes any fact that the state or the defense is trying to prove more or less likely. Okay, that's the standard of materialness or relevance. So, I'm not sure how the opinion of Mr. Miller on whether or not you should obey the law is necessarily relevant. That's what I'm trying to figure out from you, okay? They're trying to prove that on April 17th at approximately 6:39 p.m., you're driving a buggy that didn't have a light on the top, yellow flashing light. What about Mr. Miller's opinion makes that more or less likely to be true? That's I guess, what I'm...
Like you're wondering what his opinion would be.
No, you asked him what his opinion is. I want to know why that should matter, what his opinion is.
Well, I guess we're in the groove, I guess.
I'm going to allow it for now and see if there's relevance. Go ahead, ask your question again, Mr. Yoder. What was your question? I believe the question was, do you think Mr. Yoder should put a light on his buggy?
I wouldn't for myself.
All right. Any other questions?
No.
Cross?
No, Your Honor.
Mr. Miller, you can stand down, sir. Please be careful. There's a ledge there under the door. At this point, you can stay in court if you want to.
Okay,
All right.
thank you.
Do you have any other witnesses, Mr. Yoder?
No.
Do you want to testify yourself?
What does that mean?
Come up here and testify about what happened on April 17th. Do you want to do that?
No.
No? All right. You have any other evidence you want to present?
No, I don't think so.
All right.
And I can think of.
Your Honor, are you permitted to speak?
What's that?
Are you permitted to speak?
I don't know. Who are you?
I'm Corey Anderson. I'm a postdoctoral fellow at Penn State, and I am a researcher who studies both the Amish and horse and buggy safety issues.
Are you an attorney?
And not an attorney, so that's probably key.
Okay. Well, I don't think that would be a proper thing for the court to permit.
I understand.
Any other evidence, Mr. Yoder? Any rebuttal?
No, Your Honor.
Any closing argument?
Just, Your Honor, I appreciate the difficulty of the proceeding and for the defendant, but I think it's clear the defendant operated an animal-drawn vehicle on a street or highway in Ashland County that was not equipped with a yellow flashing light on April 17th, 2023.
Thank you, Mr. Copeland. How about you, Mr. Yoder? Any final thoughts from you?
About what?
About this trial that I'm trying to have.
Well, I think my conscience would bother me way too much to put a flashing light, which is electronic device, on my buggy, and feel the law of the beach, the House Bill 30, is unconstitutional and violates the constitutional rights and infringe on our religious freedom. And I would like to ask you, please, to dismiss the charge if you could.
All right, Mr. Yoder. Mr. Yoder, here's the issue, and I don't want to be seen as insulting your intelligence, okay? I don't want to be seen as talking down to you or like I think you're not smart. That isn't the case. But the most important thing to me in this room is always that everybody understands everything that happens in this room. That's the most important thing, because there's no justice without that, no matter what the court does. And you just raised the issue of the constitutionality of the statute that you were charged with back on April 17th was violated for the first time. Now you've hinted around it in some of the letters you've submitted, but that's the first time you ever said the words, I want to have this dismissed. And there are procedures and rules the court has to follow. And the court has to follow those rules even when people are not represented by lawyers, and even when people don't understand those rules. That's the law, okay? The law doesn't let me apply one set of rules of evidence to Mr. Alecki, who's a lawyer, and one set of rules to you, who is presumably a farmer or a cabinet maker or whatever you do, but not a lawyer. The rules are the rules. Now, that can result in things that I don't like. That can result in things happening that are not fair, okay? But the court has to apply the rules of procedure and the rules of evidence even to the unrepresented. There is a way, okay, to raise the constitutionality of this statute. And a couple members of your faith have done that, okay? And I have some hearings coming up where I intend to rule on the constitutionality of this statute. But you didn't do that. You didn't file a motion to dismiss. A motion to dismiss has to be filed within a certain period of time.
Ahead of time.
Correct, and it has to be filed in writing. It can't be orally made unless it's based on jurisdiction in the state of Ohio. You can't come in and plead not guilty, have a trial, and then at the end of your trial say, I'd like to make a motion to dismiss. Now, I don't mean to say that, like it's a foolish thing for you to do. It's just not the right way, and you wouldn't know that because you wouldn't know that. Okay, a lot of people, most people wouldn't know that if they're not lawyers. Some lawyers don't know that. So, I guess what I'm trying to say is, I have been from the beginning of these cases trying to encourage the Amish community to get legal representation so that these issues can be properly raised before the court. Because the procedural posture of the case can control the outcome of the case. And this is one of these. The constitutionality of this statute has not been properly raised in this case. You pled not guilty. that means you're not guilty as far as I'm concerned, and that means we have to have a trial, and that's what we've done. But the question at this trial is not the constitutionality of 4513-114. The question at this trial is, on April 17th, were you operating a horse-drawn vehicle in Ashland County? And did you or did you not have the required light? That's what the trial's about. It's a matter of fact. There's other ways to challenge the constitutionality of the statute, but that hasn't been done here. And when I look at the evidence in this case, I mean, I don't know how it could be more clear. You obviously were operating the horse-drawn vehicle. You obviously were within Ashland County. You obviously didn't have the buggy light. I understand why. But the court has no choice based on the evidence except to enter finding of guilt, and that's what I'm going to do. Anything else you want me to know before I impose sentence? The court's going to assess a fine of $50 plus the court costs, and that'll be it. Now, if you have questions about your rights, or if you're interested in an appeal, I would encourage you to speak with an attorney. Please see the clerk before you leave, and if you need time to make arrangements to pay your fines, I'll help you out if you need it. Any questions? All right. You have a good day, Mr. Williams.
Thank you.
Good luck. Okay.